Well, welcome to everyone. It's good to be back so soon in front of the jellyfish. Welcome to another edition of Law Before Lunch. My name is Richard Stevens. I bring to the table 40 years experience as a lawyer acting in and for the technology industry. I principally focus my activities now in providing contract commercial law training to law firms, large and small, as well as in-house legal departments. I also work as an ADR provider, alternative dispute resolution. That is to say, I work also as a mediator and arbitrator, principally in the area of technology disputes. That's me. Law Before Lunch, what you're listening to now, it was an idea born of the pandemic. I noticed that lawyers were floundering, trying to fill out 1 hour long webinars. I believe content is king, so I invented the idea of Law Before Lunch, which hopefully will take no more than 20 minutes or so of your time. Bite-sized nuggets of information for the internet generation, so to speak. Now, when I say bite-sized, I'm talking about the case of Tata Consultancy against the DBS. There's a service called Bailey, which provides online access to court judgments. And so when a case comes out, I always go there and I click on View as PDF to see how long the case is. And in this case, it was 248 pages. And I have to say, my heart sank. And I started to engage in what I think psychologists call displacement activities. That is to say, I thought, I need to do the ironing. I need to get the plumber in to look at that little leak. I need to get the car washed. Anything other than tuck in to 250 odd pages of densely written judgment. In the end, I started and I thought this is going to take weeks and weeks of effort. So what I did was to send out the invitations to this webinar. And there's nothing like having a deadline to force completion of a difficult task. And it was as the registrations came pouring in, and I soon went past 100 registrations, such as the interest in this case. It was fear. It was fear that drove me forwards. Fear of sitting in front of these jellyfish and making just about as much sense as them. Fear, a great driver. So anyway, without further ado, let me talk to you about this case. I cannot, in the context of a 20-minute webinar, I cannot possibly go through 250 pages of rich detail. There is so much to tease out of here in terms of the learning points. And obviously, I will be doing that in my forthcoming quarterly update on contract law, which is due for, I think, early, mid-July. And I'll be teasing out the detail of it there, because I think there is a lot that we can learn from this judgment, whether in the technology industry or whether just general contracts for the development of things or for the provision of services. There's lots we can actually learn. But if you're interested in finding out how you can join in that quarterly update, then obviously reach out to me and I'll let you know how you can join. So let me, without further ado, share my screen with you. And we're talking about this case. You should know the parties. Tata Consultancy Services, TCS, I'll call them. Huge, global, phenomenal IT services company. The disclosure and barring service, it's a service aimed principally at employers who want to make checks on recruits or for people interested in safeguarding for vulnerable people, especially children. There was a contract back in 2012 for TCS to take over from the incumbent supplier Capita, the running of business as usual activities for the DBS. It was also a contract to provide computerization of those largely manual systems. The contract was let under the OGC, Model Services Contract, OGC, Office of Government Commerce, although the judge described it as being a substantially amended version of that. From some of the words he quotes from the contract in the judgment, I would say that much of it looked familiar to me from the past. I'd like to say it brought back happy memories, but I'd be lying if I said that. I think the OGC contract is over long and over prescriptive. And some of what I'm going to say may reflect my views about that contract form. It's actually, of course, moved on a lot since 2012 anyway, and in some important respects, it's now a different draft. Now, you're saying to me at this point, okay, so this is a government IT outsourcing with a transformation project, and you're probably asking yourselves, what could possibly go wrong? Well, if you read through 250 pages of judgment, pretty much everything seems to have gone wrong. There were egregious, terrible delays with constant replanning, revised go-live dates. The DBS made numerous allegations of defects in the software that was actually provided. At one stage, the DBS purported to rely upon a contractual provision to de-scope part of the project. TCS itself blamed the delays largely on HPE, Hewlett-Packard Enterprises, now DXC. They were DBS's separate provider of IT infrastructure. And TCS's argument was basically that DBS had to take contractual responsibility for the failings of its other providers. DBS in turn replied by saying the delays were due to the flaky software provided by TCS and also the poor development services provided by TCS. As you can see there on that slide, it was a large claim, each claiming north of 100 million pounds, just so that there is no undue excitement going on. TCS was awarded in the end around 9 million pounds, and DBS was awarded 4 or 5 million pounds. So TCS got a net gain of just under 5 million pounds. Whether that is enough to pay for all their legal costs is an interesting question, and we wait to find out. What were the issues? As I say, I can't, in the context of 20 minutes, talk you through all the issues in this immensely rich case. There is so much, as I say, that we can learn from it. Each party retained the services of IT experts to look at the quality issues involved in the software. There were programming experts who were looking at the delay and analysing critical path issues. There were quantum experts looking at the damages that flowed from all the various alleged breaches. We can't go through all of that, but these on this slide were the main issues in contention. One of the issues was the scope of TCS's services. Who effectively was ultimately in charge of the whole project as a whole? And there was discussion about who was playing this role of systems integrator. If you are going into a multi-sourcing environment, as TCS was, you would be dependent to some extent upon the services provided by DBS's other providers, including in this case HPE, who were contracted to DBS to provide IT infrastructure and related services. Now, of course, HPE had no contract with TCS. They were a completely separate provider. And so the lawyers for TCS seem to have done a fantastic job in putting together a case based upon some references in the contract, just trying to say that DBS took contractual responsibility for the alleged failings of its other providers, in this case, HPE. The judge took a fairly literalistic approach to this, and he just looked at things like the definition of authority cause. And he said, well, that doesn't actually include within the definition failings of other providers. So simply put, TCS could not say that DBS was contractually responsible for the alleged failings of other providers, including HPE. I have to say, from my point of view, I find it quite extraordinary that TCS, going into what it knew was a multi-sourcing environment, didn't put in words saying, to the effect saying that DBS would procure, that is, all its other various providers would cooperate, collaborate, and that it would take contractual responsibility for the failings of any other providers that were necessary for TCS to accomplish its own contractual responsibilities. I find that quite remarkable, that there are no clear, explicit words to that effect. I find it remarkable that there was no OLA as between all the various providers, but that apparently is the case. So we're talking about a case with lots of delays, and the question then comes down to who is contractually responsible for those delays, and how does the contract deal with that? Now, a lot of you out there know me, and you all know that I love a good notices provision because they create such problems for the parties. There are numerous things that can go wrong when you include a clause in a contract requiring one party to notify the other party of something. Lots and lots of things can go wrong, not least the fact that if you bury it in the middle of the front end, and the front end to these large contracts can be 100 pages long, people just don't know it's there because the typical project manager isn't going to read the front end. He or she may read the schedules because that's relevant to what they have to do, but the front end is not something they will necessarily be looking at. So a notice period now, of course, if you want to throw a banana skin in the path of your contractual counterparty, then you may think fit to throw a notification requirement in there, or even several. It doesn't necessarily mean that the arguments will go away. Let's have a look at what can go wrong. Each of the two parties was contractually bound, albeit using different wording, at different points and on different occasions to provide a formal notification. How can this go wrong? Let's look at some of the issues that were raised here. DBS had a duty to give a non-conformance report, I think, or I forget the exact words, a non-conformance report if acceptance wasn't achieved or if a milestone was missed. And it said, the clause went on to say, well, and in that case, then you get the good things that flow in the next clause. One of those good things was the entitlement to delay payments, what we lawyers would call liquidated damages. The liquidated damages, the delay payments, were expressed to be the exclusive remedy for delay that DBS could claim against TCS. Okay. Well, the question then is, and it was common ground, that DBS never served this non-conformance report. So what's the consequence of that? So the judge looked at a number of cases dealing with this concept of the condition precedent. Now that's where you say something is a condition precedent in the sense that if you don't do it, then the entitlements fall away afterwards. So was serving a non-conformance notice a condition precedent? And meaning that if you didn't serve it, it meant that you didn't get the good things that the contract said flowed from serving such a notice. The judge said, of course, and he gave some very useful indications as to when wording would be regarded as a condition precedent. And in this case, he decided that the requirement to serve such a notice was a condition precedent in the sense that no notice meant no delay payments. No delay payments meant no compensation for delay. It's as simple as that. Now, there was a slight ruckle because the liquidated damages were only the exclusive remedy for 6 months. And the judge said, well, after 6 months, you could sue for general damages. But that's a different point. But for the 6 months of delay, the failure to serve a notice disabled DBS from its entitlement to claim delay payments. It's really important. TCS, on the other hand, had an obligation to serve a notice in the event that there was a delay. It was common ground that they had to do this in the contract within 5 working days of the relevant act or event happening. It's common ground that they didn't. But the parties carried on negotiating and replanning the project, and they seemed to be trying to move the project forward. And that gave rise to the judge giving extensive consideration to this very strange creature in English law called the estoppel by convention. Now, this deals with the situation where the parties share a mistaken assumption of fact or law. In this case, the estoppel by convention, the mistaken assumption would be that this 5 working day notice had fallen away. Now, it's not just a question of watching your contractual counterparty floundering around in a sea of confusion. It's not just a question that both parties are wrong. They have to share a common mistaken assumption as to fact or law. And the recent cases talk about something crossing the line. It's not just a question of being confused or mistaken. Something has to cross the line. In estoppel terms, there has to be this representation moving across that line, saying, effectively, DBS saying, look, we know there's a 5 working day requirement. We know you can't achieve it. We know you think it's fallen away, and we both think it's fallen away. So we'll carry on negotiating about replanning the project. The judge looked through a lot of the law in this, and he went through an extensive trawl through all the communications between the parties, and he found that there was an estoppel by convention, and that the DBS effectively was estopped from denying TCS's entitlement to compensation for delay, even though it hadn't served a notice within those 5 working days. The judge also looked at this question of termination for material breach, this partial descoping, and he looked at some of the law on what amounted to an irremediable material breach. And in the particular circumstances of this case, the egregious delay, he said that they had not made out their case on irremediable material breach. Now, I said I would look at one of these areas in a little bit more detail, and I thought, what gets lawyers cranked? And let's face it, it's liabilities, isn't it? It's liabilities drafting. Now, you'd think after all these years and with all this experience, any lawyer would be able to sit down and draft a liabilities clause and get it right first time. And I went back through my notes on previous cases. And I looked at this case, which I thought was very striking, Persimmon Homes case. You can have a look through as I talk, the very simple wording which provides cap on liability and also an exclusion of liability in those last few words in the second sentence. The judge observed that the wording was almost identical to wording that occurred in the technical proposal, and he surmised that the wording was actually drafted not by a lawyer but by an engineer or a commercial manager. And he described this wording as shorn, as he put it, of lawyers' accretions. And he said it was simple wording that could be simply applied. And he did so. And the Court of Appeal agreed with him. More recently, I've been talking about this case, the Southeast Water case. It was a limited warranty set out in Schedule, I think, 11, a technical schedule dealing with what happened to defects in the metering systems and transponders being provided by Elster to Southeast Water. And it said very simply, should a faulty device be identified, cost of an equivalent replacement device, incidental costs limited to the warranty are set out. And there was a little table setting out an entitlement to minimal compensation of £40 or something in certain cases in the early part of the contract. And as the judge said, it's frankly hard to see how its wording could have been improved. It has the undoubted merit of simplicity and clarity instead of being concealed in a thicket of legal boilerplate. Again, this was wording, as the judge said, that was probably drafted not by a lawyer, but by an engineer or a commercial manager. And it's with that, by way of background, that we come to some of the wording in the TCS and DBS case. What could possibly go wrong? Well, let's take a look through it. The contractors, there were 3 issues coming out of the wording on this slide. Contractor's total aggregate liability, and that suggests immediately, doesn't it, that you're talking about a lifetime contract liability for the contractor, for TCS. In respect of delay payments, it should be limited to 10% of the implementation charges. So that's saying that liquidated damages, LDs, will be limited at maximum to 10% of the implementation charges. Now, what I've put there on that slide is not in fact a typo. Charges has a capital C, implementation does not, because it's not defined anywhere in the agreement. But it goes on, 52.2.6. In respect of all other claims, losses, or damages, limited to 100% of the charges paid under this agreement during the 12-month period immediately preceding the date of the event giving rise to the claim under consideration. Ouch. Well, you can see immediately a clash in the wording. It opens talking about the contractor's total aggregate liability, which I would take, and most people would take to meaning the lifetime contract liability that the contractor could possibly have. And then it seems to lapse into the language of talking about a per event per claim type of liability, 12 months preceding the date of the event in the singular. Well, what does that mean? Is it one cap or is it multiple caps? Finally, it talks about neither party will be liable to the other for any loss of profits. So let's look at those three issues and see what the judge made of them. Delay payments. As I said, implementation was not defined anywhere in the agreement. Charges with a capital C certainly was. TCS's lawyers did a grand job in trying to identify what the implementation charges would be, and they said it must be this particular module here, trying to find that the delay payments would be limited to 10% of that sum, and that would be about 290k. But the judge said, well, it's not defined, so it doesn't exist. So there's no limit to delay payments. Ouch. One cap or multiple caps? Well, this is not the first time this has come up in recent years before the courts. I think this wording came originally from an OGC form, or certainly another government form of contract, and it's since made its way out into the private sector as well. It was looked at in a government contract in the Royal Devon case there, and also very recently at the end of last year, Drax Energy against Wipro. It came up before the courts again, where the parties are trying to have a total aggregate contract liability, but then they pegged it to a per event 12 months before the relevant event. And as the judge said in this case, it can be noted that the judge in Drax entirely understandably considered that the clauses were not well drafted. In the present case, the same is true. Clause 52.2.6 is far from a model of clarity. So was it one cap or was it multiple caps? It wasn't strictly necessary for the judge's decision. As we have seen, the amount of damages awarded to each party was much lower than their actual claim. But he said basically this indicator, the wording taken as a whole, indicated a single aggregate cap, no matter how many events, how many claims, how many losses, or how many claims for damages individually there might be. There was no language in this wording of a per claim limitation on damages. However, he went on to say, and it wasn't necessary for his decision, he went on to say, well, it's not exactly clear how that would work because it's probably a reference to the first claim. So in other words, you go back 12 months before the first claim, but then again, there could be a series of claims in a long-term contract. So if there's a later claim, which happened to be bigger, then that might set the cap at a higher sum. He said he mused about this, but said it's not necessary to decide on the facts of that case. You have been warned not to use this type of wording. Lots of profits. We went through a drought for years with hardly any language dealing, any court decisions dealing with the meaning of this expression, which is almost ubiquitous in commercial contracts. And it came up recently and very significantly in this case, Soteria against IBM United Kingdom, where it went up to the Court of Appeal. It said that really what you're looking at is a distinction between speculative damages. A loss of profits is entirely speculative. You don't know what your profits would have been but for the breach. You get a good accountant on it. You could turn a thumping loss into a profit and a profit into a thumping loss. And the idea, said the Court of Appeal, behind excluding a liability for loss of profits is precisely so that the parties don't get engaged in speculative claims, and it focuses their attention on making claims for things that can be definitely proved. And a good example of that, of course, would be wasted expenditure. Now, what TCS was claiming in this case was they were saying, look, we failed because of you, DBS, we failed to make the anticipated savings later on in operating this contract. DBS said, well, that in all but name is a claim for loss of profits. TCS said, well, it doesn't really matter what we call it. Failure to make anticipated savings is not actually named in this wording, so we're going to claim that instead. And the judge looked at this and he said, well, it applies to both parties. He accepted this distinction between speculative losses and actual wasted costs. And he said, basically, no matter how you put it, TCS, you're making a claim here for loss of profits. It doesn't matter how you badge it, it doesn't matter how you characterize it, it still basically comes back to a claim for loss of profits. And he said that was therefore excluded as a point of claim in this case. So what do you make of all this? I say there's so much. This case is replete with detail. And there's a lot, really, that you could say about this. And as I say, in my next quarterly update, I'll be going through the learning points in more detail. So what are some high-level thoughts? Well, when it comes to liabilities drafting, maybe we should get the engineers to do it instead of the lawyers. Based on those recent case law, I mean, they seem to be perfectly capable of making a good job of it and probably better than the lawyers. And you're probably saying to yourselves, well, that's Richard being flippant again. But maybe the engineers know something that lawyers don't, and they appreciate that less is more, that simplicity is better than complexity. I've given you some of the wording in that particular contract. It was actually other wording. And then once you get into very complex wording, you get good counsel on it, and they can start to find lots of little inconsistencies that you can work on to try and punch holes in the drafting. If you keep it simple, you can't really do that. There's another point that comes out of that, of course, and that is you can bury bad news in the technical schedules. The lawyers are less likely to review it. So if you, like in South East Water, you put the limited warranty, the exclusive remedy, in Schedule 11, it's less likely that the lawyers will look at it and pick it up. But it's simple, it's effective, shorn of lawyers' accretions, and it was upheld. You may remember me talking some years ago about this Højgaard case as well. The relevant warranty that these offshore wind turbines would have a minimum lifetime of 20 years was buried in the technical proposal, thousands of pages long, annexed to the contract, incorporated by reference. It went up to the Supreme Court and they said, it doesn't matter where it is. It doesn't matter that it's not in the front end. It matters that it's there in a contractual document and it's going to be given contractual status. I throw the point out there for you. The other point is this, and I said earlier that I wasn't a fan of OGC forms. They are immensely long. And the problem is when you come with a standard form contract, a lot of people coming to the transaction will simply take everything that's there and they'll take it as read. And they won't think, well, is this strictly relevant to the project, to the specific transaction I have in mind? That may or may not be a good thing. If you have a very long contract dealing with lots of different situations, it may well be a bad thing. Looking at that liabilities clause, this wording is going the rounds at the moment. We've seen several cases dealing with it. It's gone out into the private sector. A lot of people, I think, a lot of lawyers tend to be a little bit shy when it comes to putting their hands up. And I think the advice I'd give is, look, if it doesn't make sense to you, it probably doesn't make sense to anyone. You're all bright boys and girls out there. And if it doesn't seem to add up, if you've got a clash between total aggregate liability and then wording that's suggesting a per event claim, if it doesn't make sense to you, it probably doesn't make sense at all. Speak up, challenge the wording. Just because it becomes in a standard contract doesn't mean to say it actually makes sense. Notification clauses. There's lots I could say about these, lots and lots and lots. I remember a case I was on some years ago, and I was acting for the provider in this huge outsourcing contract. And if we suspected any delay being caused by the customer, we had to give notice within 14 days. And I called that out straight away. And I said, no, people just don't give notice. And it's just riding for a fall. And this was one of the long-running sores in this months-long negotiation. I remember the last meeting, the IT director for the customer, I mean, literally fists were coming down on the table talking about this and a couple of other points. And the way we got around it in the end was to say, he said, look, I just want to know if there's any problem that I need to deal with. And that's a fair thing. And so the compromise wording we said was, we don't have to give you a formal notice. It's just good enough if we have told you as part of governance, if we've emailed you something in writing that tells you what the failings are, and you know, therefore, what you have to do. And when I was called back onto that project about a year or two later, when it had all gone horribly wrong, one of my first questions was, well, what have you done by way of governance to stick the blame on the other side? And my client said to me, well, he's such an irascible old so-and-so, we thought it best not to say anything, so he didn't. And I could have wept tears of frustration because I had worked so hard to try and protect my client's position, and they've just thrown everything away by that decision. So beware of notification clauses. You need to know what is a condition precedent. Are you drafting it to be a condition precedent or not? It also is very relevant, this estoppel by convention point. It's also very relevant for when advising on projects in trouble. You really need to know what is an estoppel by convention. If you're in a dispute situation, it's unlikely that the other party is going to come to agreements with you as such. And we all know from the recent rock advertising case that if there is a no oral modification clause in the contract, as there likely is these days, if there is such a clause, then having oral agreements isn't going to cut it. But you do need to know what constitutes an estoppel by convention, such that you can be maneuvering your oppo into a position where you can later argue that they are stopped by convention or stopped by any other means. Well, those are the points I wanted to bring out today. I've brought that in just about 20 minutes, which was a big challenge. It's a case, as I say, replete with learning points, and I will be picking those up in my next quarterly update on contract law and my annual updates on contract law. I think there is so much there that lawyers can learn, so much there that business people can learn as well in the points to look at in a contract, and also how you manage these large projects and how the law interacts with that. But that's what I wanted to say, and I'm happy to take any questions that come through, but otherwise it was fun to do. Thank you everyone for giving me the incentive, namely fear, to finish the job of reading this case and putting this mini webinar together. And I hope to see you next time.